Supreme Court considers constitutionality of independent redistricting. Hundreds of congressional districts might have to be redrawn. The Supreme Court on Monday will hear arguments that it's unconstitutional for a state to isolate its legislature from the redistricting process, citing the federal constitutional election clause. And if the court sides with the plaintiffs, it could upend political districts and election laws from coast to coast before 2016. Hundreds of congressional districts might have to be redrawn before the next election, and several other election laws could be at stake, depending on how broadly the High Court rules in a much-anticipated case brought by the GOP-controlled Arizona Legislature against the State Independent Redistricting Commission. The legislature is claiming that the Constitution, which states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, prohibits voters from taking the redistricting process out of the political arena. But the case could do more than just dismantle the Independent Redistricting Commission that good government groups have been championing for decades. It could invalidate some state election laws, such as those related to voter identification, regulation of primaries, and residency requirements passed through ballot initiatives. Quote, the stakes are actually pretty ginormous, said Justin Levitt, a redistricting expert at Loyola Law School in Los Angeles, who filed an amicus brief on behalf of Arizona's commission. Quote, this case only looks like a redistricting case if you aren't paying attention, but it's really about who makes the rules for election. It will have an effect far beyond Arizona and far beyond redistricting. Arizona's Independent Redistricting Commission was created when voters in 2000 passed Proposition 106, an amendment to the state constitution that gives the responsibility of drawing congressional lines to an independent 5-member body. 4 of those members are chosen by legislative leaders from a list prepared by another state agency, and the 5th member, the chairman, is elected from the same list by the other members. The Arizona State Legislature believes that its lack of power to modify or reject the maps produced by the commission violates the election clause. Arizona's use of the Independent Redistricting Commission to adopt congressional districts cannot stand, the legislature says in its brief submitted to the court. By design, the legislature has been completely divested of all authority to prescribe congressional districts. That power has wholly been transferred to the IRC, which is not and cannot claim to be the state legislature. While it's Republican from the Grand Canyon state who are sitting, the map the commission drew in 2011 led the Democrat winning 5 of the state's 9 House seats in 2012. Support for redistricting reform is fairly bipartisan. Then California Governor Arnold Schwarzenegger championed the issue during his time in Sacramento, and 9 of the 20 members of Congress who filed briefs supporting the commission are Republicans. The members of Congress argue that the Arizona legislature is advancing a cramped and ahistorical interpretation of the election clause. California is the only other state that has independent commissions set up through ballot initiatives. But 5 other states, Hawaii, Idaho, Montana, New Jersey, and Washington, that draw their lines through commissions with some involvement from legislature could also be affected. In fact, advocates of nonpartisan redistricting fear even the maps that have had to be drawn by the courts, like New York's, after the legislature failed to produce a map by early 2012, could be thrown out. Gene Rea, vice chairman of California's commission, said there's a lot of concern in the state that the court's decision will undo what was clearly done by the people of California in creation of a commission that is fair and transparent. Quote, We're all watching this carefully and just looking forward to Monday, Reyes said last week. I don't know how strictly the court will read the meaning of legislature. Are they going to recognize that in a democratic society, it's the people who have the power? In a brief signed along with two other former California governors, Schwarzenegger added, the historical record regarding the election clause confirms that the clause does not limit the legislature means by which congressional districts may be drawn, and that the clause accordingly permits the people of a state to delegate that power to an independent commission. But the National Conference of State Legislatures, which filed a brief supporting the Arizona legislature case, believes the case is being viewed too broadly by the other side, distracting from the redistricting issue at hand. Invalidating Arizona's commission won't necessarily mean the court will throw out election law across the country, NCSL said. People have really taken the case and run with it, says Susan Frederick, Senior Federal Affairs Counsel for the NCSL. It's pretty straightforward case from where we sit. We'll have to see how the Supreme Court chooses to interpret it. Frederick said redistricting reforms advocates have turned the case into more than it is. If the sky falls down, what will happen, she said of their reaction. I'm not a Supreme Court guru, she acknowledged, but I do know that the Supreme Court isn't prone to these broad stroke rulings. They usually go for the most narrow ruling. The case is Arizona State Legislature versus Arizona Independent Redistricting Commission. Do you think if they throw out the maps, if they throw out the commissions and invalidate the commissions, that Obama might stay in office because the elections will all have to be postponed? That's what I'm getting from this. Thank you for watching the Shikama Live Show.